public briefing.
So far away.
In fact, he's not there either. He's out of camera shot.
I feel like sending a sort of water bottle over.
Okay. Good morning.
Morning.
I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Intelligence Services Amendment Bill 2018. These are public proceedings, although the committee may agree to a request to have evidence heard in camera and may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of the evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. In accordance with the committee's resolutions of 12 October 2016, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. Those present here today are advised that filming and recording are permitted during the hearing. I also remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. I now welcome the representative from the Australian Secret Intelligence Service to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Thank you, Chair. Paul Simon, Director General of the Australian Secret Intelligence Service.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Director General, over to you for an opening statement.
Thank you, Chair. Thank you, Deputy Chair. Thank you. And thank you, members of the committee. On behalf of all of the officers of ASIS here and overseas, I'd like to express my appreciation for the timely manner in which you've been willing to conduct this public hearing. Your support and oversight will give legal clarity and legal certainty to our officers in situations where we rely on their training, their experience, their quick decision-making and strong instincts in order to achieve an outcome in Australia's national interest, with the least amount of escalation, the least amount of use of force and the least amount of publicity. As the responsible officer for their care, their well-being and their lives, I am most appreciative of this opportunity to testify today. It is difficult in this public setting to be completely candid about the circumstances in which our achievements have come about, including the specific hazards officers have overcome in the course of their duties, nor the lessons learnt from many recent ASIS activities, especially those in relation to Section 61E of the Intelligence Services Act, nor the variations or hypothetical scenarios born of this experience that we prepare and train for. There has been considerable change in the operating environment for ASIS officers since the original passage of the Intelligence Services Act in 2001 and subsequent amendments in 2004. Since then, successive governments of both complexion have benefited from an agile and covert agency like ours and have asked ASIS to do more in response to national security priorities and unfolding global or human events as they press on our national interests. The bill seeks to amend the Intelligence Services Act to enable ASIS to protect another person or class of persons specified by the Foreign Minister, that is beyond the protections already legally available to defend the life of our own officers, that is employees of ASIS and our agents. An Australian being held hostage overseas might be just such an example agreed to by a Foreign Minister. The bill also seeks to amend the Intelligence Services Act to enable the use of reasonable force by an ASIS staff member or agent in undertaking specified activities outside Australia in the proper performance of an ASIS function. The First Amendment addresses a legal uncertainty identified by the Australian Government Solicitor in the ability of an ASIS staff member to be compliant with the Act when defending certain other persons, for example a hostage, and to train for the use of force in those circumstances. The Second Amendment addresses several grey areas in the use of force under the Intelligence Services Act, particularly the use of reasonable and limited force to restrain, detain or move an individual who may pose a risk to the risk of the compromise of an operation or where a staff member anticipates a possible safety risk. Some key points that very much become my responsibility to ensure comprehensive understanding by all my officers should these amendments pass. Firstly, The ability to use force only applies where there is a significant risk to the safety of a person or where there is a significant threat to security or significant risk to the operational security of ACES. Secondly, the use of force must be proportionate, the minimum reasonable force given the circumstances. Third, before directing a specified activity, the Minister for Foreign Affairs will be required to consult with the Prime Minister, the Attorney-General, the Minister for Defence and other relevant ministers. Fourth, oversight will include key roles played by the Inspector-General of Intelligence and Security and the Parliamentary Joint Committee on Intelligence and Security. Fifth, the Inspector-General will need to be provided with copies of the ministerial approvals to undertake these specified activities and copies of ACES's guidelines on the use of weapons and the use of force. Sixth, additionally, the Inspector-General, on receipt of the guidelines on the use of weapons and the use of force, or changes to them, would be required to offer to brief the Parliamentary Joint Committee on Intelligence and Security on the content and the effect of the guidelines or the changes. And finally, the Minister for Foreign Affairs retains the authorisation power in relation to the training of ACES officers in the use of weapons and the deployment of such weapons. With these key points in mind, I'd be happy to answer your questions, unaided by staff or legal counsel given this public setting. On secrecy or sensitive matters, or should there be legally complicated questions, I forewarn you that I would probably need to take the question on notice for a private briefing in an hour's time. But in the spirit of helping, I'd like to be as forthright as I can with the committee on any questions you have.
Thank you, Director General. Senator Wong.
Thank you, Chair. Thank you, DG. That's a reasonably comprehensive opening statement, and I might just retraverse a couple of the comments you've made in there. So first, the context, of course, is 2004, I think, Parliament amended the Act to enable ACES officers to undertake training and also utilise self-defence techniques and weapons for the purpose of protection. That is subject to ministerial approval. There were strict limitations that Parliament put in place, and this legislation goes to changing some of those limitations. So I just wanted to start by asking you to reprise why it is important that those limitations be altered first, and then I want to go to the boundaries of that and the oversight.
Senator, I think the main reason for the changes are born of experience. I think that the changes in 2004 were very much born of working with the ADF, providing force protection to the ADF in theatres like Iraq and Afghanistan. Mm-hmm. In the last 2.5 years in particular, hostage taking both in warlike zones but in non-warlike zones like West Africa have led to a situation where should a benefactor be willing to pay for a hostage's release, the question then becomes who should give effect to that handover. And there have been occasions where government has looked to ACES in a deniable way to effect that handover. And really what I'm seeking to do here is take beyond any doubt any legal limbo of the status of our officers in those very difficult and trying circumstances.
So just to reflect that to you, the assertion is, or the situation is, that the circumstances in which your officers find themselves require the potential for protection to be provided to persons other than in self-defence.
That's right.
Right. And so therefore the amendments in the legislation which seeks to enable the Minister to specify additional persons who can be protected by ACES members or agents is directed at those sorts of circumstances. That is the operational exigencies people currently experience, correct?
That is correct.
There's also the reasonable and necessary force provisions. Could you explain again why the current limitations around reasonable use of force in self-defence activities need to be extended in the way the Act provides?
At the moment, the Act, Senator, really provides virtually no ability to provide limited or proportionate force, and all of a sudden we escalate to the other end of the spectrum where we actually have to fire in self-defence, in self-protection. So the spectrum is sort of 0 to using weapons in self-defence. Again, our experience, and I'll use hostages because I think it evokes an image that I think the general public would appreciate, that in the circumstance where a hostage is being handed over, if an Australian benefactor, for example, provided the resources to release a hostage, the hostage, whether he or she is under incredibly difficult circumstances, they are probably quite possibly the effect or the handover is going to be, in the middle of the night. They will have been not particularly well looked after for a period of time. So anxiety levels are very, very high. So I think the sort of scenario I can see here is where in looking after the hostage, there may be a circumstance where we might need to hold them on the shoulders and throw them into a car. We may actually need to achieve the effect that we're trying to accomplish here, use limited, proportionate, but in some cases some limited force to achieve the outcome. So that's the type of scenario that we envisage. It's not in our interests to apply any more force than would be necessary to achieve the outcome, and so that's why, from the Act's point of view, it absolutely uses the right terms like limited and proportionate. It really is incumbent on me and the training of our officers to make sure that they have the right skills, the right experience and training, the scenario role plays and the like, to be able to understand what is limited and proportionate for the circumstance that they find themselves in.
And to the extent you're able to in this context, are you able to just give some evidence as to why the existing split as between the ADF and ACIS, which the 2004 amendments presuppose, have less utility while are more operationally problematic today?
I think there have been circumstances, again, in the past few years where in warlike scenarios, clearly the ADF capability, the Special Forces capability, is and should be the government's capability of choice. Their training, the breadth and length of their training is different to ours, but there are scenarios where either the hostage's family, the government would like deniability as we go through the critical moment of a hostage recovery, but in a very low-key way. And so, and often that's the way families prefer this to occur. So what ACIS provides for government is another option that can undertake activities like this, but from my point of view, don't leave my officers in legal limbo in this sort of limited spectrum from 0 to only being able to fire in self-defence.
Thank you. And finally from me, just in terms of oversight, just to confirm, there's no reduction in the oversight of ACIS, this capability proposed by the legislation?
No, there is no reduction. If anything, I would say we have suggested into this Act and into this amendment a willingness to share with the, subject to the Inspector General, but there are provisions there for the actual procedures, the training procedures that we develop inside ACIS. Should the Parliamentary Joint Committee wish to see those procedures, then the Act allows for such an arrangement. Traditionally, of course, the committee has been confined to the administration of the Secret Intelligence Service, but certainly I think the sharing of what our internal rules and procedures are to assure you that we are training and have proper provisions internally in the service to give voice to these amendments, I think is actually an additional improvement to the Act.
Yes, and we appreciate that. Can I just finally just place on record, I have appreciated and the opposition appreciates the sensible way in which ACES has approached the Parliament on this issue. We've appreciated the non-partisan way in which you've approached it, and we also appreciate your recognition of the importance of oversight when additional powers are being sought, that is one of the ways in which both the Parliament and the community, I suppose, it is an important aspect of maintaining confidence in the national security arrangement. So we appreciate the bill as drafted and we appreciate your engagement with us ahead of this.
Thank you, sir.
Senator Molan.
Thanks, Chair. I have. Thank you for your opening statement. That was quite complete, and my experience of what you do is been tremendous, and I can only second what Senator Wong has said. I see the need for what you're requesting, and I see the logic behind it. And Chair, I have no further questions.
Thank you, Senator Molan. Senator McAllister.
Thank you, Mr. Simon. Nice to see you here. Can I just ask about the guidelines? The EM explains the requirement for the Director-General of ACES to issue guidelines in relation to the use of force, and that those guidelines will set out how officers might interpret terms such as reasonable, necessary and proportionate. In the most general terms, can you explain the effect of having such guidelines in place for an organisation like ACES?
Well, the effect of the guidelines is that they then permeate deeply into training, and you know our training arrangements. You've seen our training arrangements, but you also know the investment we put into training scenario role playing in in the way that we prepare our officers for any number of situations that they can find themselves in. So, should you pass these amendments, and we already have underway the drafting and the development of the guidelines, but clearly I have to satisfy myself that when you eventually see the guidelines, you'll be satisfied that they reflect those guidelines. From my point of view, the most important thing is that then in our training regime and the scenarios and the role plays that we do, that all of our officers fully understand and are practised in and role play various scenarios, and so that we can actually judge whether, in our view, they are demonstrating the sort of qualities that we want. People who can look at a scenario and say, okay, well, here is the appropriate response to that. Clearly, if people don't perform well in training, that's where they will make mistakes, but that's where we will make sure that they are debriefed if necessary. If they don't improve, then they may be taken off a course. But that's the way I see it cascading through to the operation of the service.
Okay, so ACES takes steps to ensure that officers are trained in the practical application of the guidelines for any scenario they may encounter. Do the guidelines have any additional effect in real operational situations? They constrain and guide what may happen under those circumstances also, do they not?
ACES has a long-worn tradition that after every operational activity we will critique in quite a robust way the performance of our people and whether we achieved the outcome, as I said at the very outset, with the least amount of force, with the least amount of publicity. So it is true to say that every activity will inform other activities. Every individual will be very robustly critiqued on whether they followed the tenets of proportional and limited force. Our expectation is they will, but it doesn't mean that it will just be, the activity will be completed and that's the end of the matter. There will be assessments done inside ACES. We have always done that with all of the operations that we undertake. And
your earlier evidence was that those guidelines will be assessed by the Inspector General of Intelligence and Security, both at the point at which they're made and if there are any subsequent changes to the guidelines.
That's correct.
And it is also then the obligation of the Inspector General to brief the PJCIS about the content of those
That's correct,
guidelines.
Senator.
Thank you, Chair.
Thank you. Director General, thank you very much for the way you've engaged with the committee over the past year and a half. We do appreciate it, and it's made this process a lot easier.
Can I second that on a bipartisan basis, and just wanted to commend you. I've dealt with a number of the Director Generals of ACIS, and this is by far the best process of consultation and briefing of the Chair and myself, and I'd just like to thank you for your frankness and your thoroughness and your willingness to explain the situation to committee members.
Thank you.
Thank you. I think you've made a very sensible case based on the threat that ACIS officers encounter overseas, the type of operation that you described, the hostage recovery, the legal ambiguity that we need to address. If I turn to paragraph 54 of the EM, it talks about the practical reality of such operations and the necessity for interoperability and training for officers of multi-agency teams in circumstances involving threats to national security or safety of a person overseas. This would include, for example, officers from state and Commonwealth agencies such as the ADF who are authorised in their own capacity to carry and use weapons, as well as officers from approved foreign agencies. ACIS obviously works with a lot of different partners, particularly from the Five Eyes community. It seems like this legislation would just be standardising us or getting us to best practice so that we can optimise operations. Is that a fair characterisation?
Well, I think it's a vast improvement. It doesn't standardise us in the Five Eyes community. CIA, my American counterpart agency, has significantly more power than we do. We're not seeking that expeditionary special forces type of role for ACIS. It's not our intent whatsoever. So I would say on the spectrum of Five Eyes capabilities, we're probably, I think sensibly in about the midpoint. For me to push this further, I would say firstly we have other capabilities. The nation has other capabilities that it can call upon. ACIS is a small organisation, and for us to take on more, I think is unnecessary at this point.
So just a very sensible streamlining of...
I think so.
Yep, okay. Thank you very much.
Thanks, Chair.
No further questions? Thank you for your evidence today. We'll get a transcript to you for corrections.
Thank you.
Appreciate it.
Have you worked with him, Andrew?
Who?
The Director General? Paul?
Not really.
Special Forces. In terms of the process, Director, Andrew, I meant that in the sense that he's...
That's right. And just to be clear, Director General, we're not going to request a private hearing, so if you've got other business, feel free to attend to it.
So you don't need us?
Oh, sorry, the Inspector General.
Director General.
Director General, sorry.
Sorry, I thought you were...
No.
We need you.
Yeah. All right. One moment. I now welcome representatives from the Inspector General of Intelligence and Security. For the Hansard record, would you please state your name and the capacity in which you appear before the committee?
Margaret Stone, Inspector General of Intelligence and Security.
Jake Blight, Deputy Inspector General.
Steve McFarlane, Assistant Inspector General.
Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make an opening statement before we proceed to...
Just very briefly,
Sure.
that might expedite matters. We have been consulted in quite a detailed way on the development of these provisions, and in a very cooperative way. We have made suggestions which have been taken up, and without commenting on the policy, we have no problems with these provisions.
Thank you, Inspector General. Senator McAllister.
That does expedite things quite a lot, Ms Stone, thank you. When did consultation commence on this? When you say you were consulted in quite a detailed way, what does that look like?
Well, we were given an early draft on the 20th of November, a further draft, I think later the same day. On the 22nd of November, we were given a draft version 5, and on the same day, a later version. Then again on the 23rd of November and the 26th of November.
Right, so you were in a position to provide comment on successive iterations of the bill as the drafting progressed. And that is very different to the approach that has been taken to the Access and Assistance Bill, where you were not provided those opportunities until after the bill was made public.
Yes.
I think when you say you have no problems, what you're saying is that you are comfortable with the oversight arrangements that are
Yes, I think
provided
the
for?
oversight provisions, as the Director General said, oversight hasn't been restricted in any way. In fact, I would agree that I think it has been increased insofar as the expanded powers have provided for oversight by us, and we're comfortable. Our comfort derives not only from what we think in this bill is sensible provisions for oversight, but the fact that our experience, our experience with ACES is that they are very concerned about compliance. They build it into their operations, and they have, I think, a very committed approach to compliance, and we do rely on that. Doesn't mean we don't inspect and look very rigorously, but we get a lot of comfort from the culture of compliance in ACES.
And so the culture of compliance produces outcomes in terms of actual compliance?
Absolutely, absolutely. And which doesn't mean that mistakes don't happen.
Of course.
But in many cases we are proactively advised of problems.
And just for the benefit of the committee, can you just step through the key points at which your office may exercise oversight in relation to the powers that are set out in this bill?
Do you want to do that?
Certainly. Look, so there's a range of powers. So there's the Minister must give the Inspector General copies of guidelines. In practice, we anticipate ACES will, as they have in the past, consult us during the development of those guidelines. The new measure is that there's an express provision that the Inspector General must offer to brief the committee on those guidelines, and that it covers not only the new Schedule 3 guidelines, but they're expanding the current oversight in relation to Schedule 2, the self-defence provision, so that we could brief the committee on those guidelines as well. They are also subject to periodic review, so the authorisations under Schedule 3, the use of force ones, the Minister must review them at least on an annually basis. So that's another opportunity to ensure that things have been gathered, considered, collated and reviewed every year. We also have requirements that ACES must notify us as soon as practicable, not only of any use of a weapon, but any use of force. So under Schedule 2 today, it's only use of a weapon. The expansion, which will cover Schedule 2 and 3, is any use of force and use of a weapon. And again, as the Inspector General said, ACES is very diligent in proactively briefing us about issues. For example, we've reported in our annual report some, I would describe as fairly minor and administrative issues where, for example, weapons have been used in a safe but unapproved location for training in a weapons range that wasn't properly authorised. ACES are very diligent about notifying us even of those quite small issues in a very timely way. So there's a range of opportunities. In addition, the Inspector General does visit training facilities and view training periodically, and our staff inspect that sort of thing. We also inspect the weapons registers and their internal auditing of weapons, you know, where are they, how many are there, ammunition, that sort of thing. We inspect their internal mechanisms and find very few errors in those.
Thank you. Thank you, Chair.
Thank you, Senator. Any questions?
No, I have no questions.
Dr. Killier?
Very comprehensive.
Thank you very much, Inspector General. Sorry? No, I don't think we have a private hearing. No. As usual, we'll get your transcript to you for corrections. Thank you very much. I now declare this public hearing closed.